Welcome to Carlisle's Chesapeake, and today we have as our guest Bill Anderson and Dave Menotti. They both have worked as environmental lawyers, Dave in the public and private sector, and Bill in the private sector. Bill has been with law firms headquartered in Houston, Chicago, and Richmond, Virginia.
Yes.
And Dave has worked with the EPA for many years, as well as represented trade associations among other private clients. So welcome,
Correct.
gentlemen.
Thank you.
Thank you.
Good morning.
Our topic today is why the EPA, why the Environmental Protection Agency. And it's a pretty heavy load, but I think we're going to cover it pretty well. So if you could, Bill, talk to us about air moving and water flowing.
Well, obviously water flows. We know that water flows downhill. The Susquehanna River is a good example. We have many states affected by and surrounding the Chesapeake Bay whose waters, the quality of the water in the Chesapeake Bay depends upon contributions from the Susquehanna River. So an upstream state has the potential to pollute or cause pollution in a downstream state because water flows. The same is true in air sheds. You have air moving from one state into the next. So pollution in Ohio or Pennsylvania, for example, from coal-fired power plants will end up affecting the air quality in downwind states like Maryland or New York. Because of this, there needs to be some kind of overarching regulation to prevent those upwind or upstream states from adversely affecting the downstream states. And that has been our federal environmental law and oversight by EPA, and specific obligations by EPA, for example, to reduce or cause upwind states to reduce their air pollution. Currently, our Maryland Attorney General, Brian Frosch, has a lawsuit against EPA contending that EPA has not done enough to protect Maryland's air quality by forcing upwind states to reduce their pollution. And we all know that we have a pollution diet for the Chesapeake Bay called the TMDL program that is from EPA under the Clean Water Act. And the states, 7 states, are now required to achieve a pollution diet and to achieve reductions to enhance the water quality of the Chesapeake Bay, particularly reducing nutrient pollution and sedimentation in the bay.
Dave, if you would, please talk to us about the risk factors, the standards, and the technical standards.
Well, I mean, one thing that is fairly commonplace observation is that environmental law is very complicated. And anybody who's tried to look at the Clean Air Act, for example, would agree with that statement. But at the bottom, at least in the standard setting area, it's pretty simple. There are 2 kinds of standards you can set: risk-based standards and technology-based standards. Let me talk about technology-based standards first because they're the simplest. Essentially, technology-based standards involve dialogues between engineers and economists to try and find the sweet spot in a pollution control technology that's going to give you the most bang for the buck. And in effect, it's the same kind of decision making that we as individuals make when we buy something. You go out and buy a car, you can buy a Chevrolet or a Cadillac, but maybe the bang for the buck for your pocketbook is with the Chevrolet. So that's technology-based standards. Now, risk-based standards are a little more complicated. Essentially, what you're trying to do there is look at somebody standing outside the fence line and say, are the emissions from this plant, for example, going to harm that person? And that involves understanding what's coming out of the plant and then asking questions of toxicologists and epidemiologists about what the hazards are of that substance. I mean, how much of it is going to hurt somebody? And then talking to chemists and modelers to figure out how much is going to end up getting from the smokestack to the person standing outside the fence line, and then deciding whether there's an ample margin of safety. In other words, the levels that they're seeing are not going to harm them with a safety margin built in. And then they go back in risk-based standards ultimately and talk to engineers again and say, okay, there's the level we want to achieve. What do we got in the technology suitcase that will reduce emissions enough to get us to where we want to get?
In these breakouts here that we're talking about, we haven't defined how those regulations come into effect, that in fact it's a law that's passed and then regulations take place. Is that correct?
That's right, and that's one way you get there. One of the major ways. First, we obviously have to start with a statute, and the statute will impose obligations on EPA to set standards. Examples: the Clean Air Act requires EPA to identify so-called criteria pollutants. Those are things that are commonplace in the air everywhere. Sulfur oxide being one. Photochemical oxidants, which we think of as smog, is another. And then it requires EPA to set health-based standards to say what levels are acceptable on street corners for each of those pollutants. And then the implementation is actually left primarily to the states, which makes sense because for many of these things there are many sources, and local decisions have to be made about what things make sense to regulate and what things make sense not to regulate, with the important caveat that there's federal oversight to make sure that the ultimate objective of achieving acceptable ambient air everywhere in that jurisdiction is achieved. That's one example, but it all starts with a law. Congress doing what it's supposed to do and setting hopefully fairly broad giving fairly broad commands to the regulatory agency that the regulatory agency then in turn implements.
So Bill,
In that context, these criteria pollutants are regulated through looking at the ambient air. What are the concentrations in the ambient air? And then the states have to translate the levels, maximum permissible levels in the ambient air, back to individual sources to say, okay, well, this source under the permit is going to be limited to X pounds per year or X tons per year for emissions in order to assure that these national ambient air quality standards can be met in this region. And there's some regions of the country, for example, the typical example is the Los Angeles Basin,
Houston,
yeah.
or
New York City, or that do not currently achieve these ambient air quality standards. The air's too dirty. So they are called non-attainment areas. They do not attain the ambient standards that EPA has set to protect public health. And there are complicated programs and requirements for each state to limit further the pollutants that can be emitted within those states.
Now, I gave you an example of the Air Quality Management Program and the Clean Air Act, but there are other situations. I'll give you another Clean Air example where EPA sets, but through regulation, nationally, standards that apply nationally that don't require state implementation. The New Source Performance Standard Program under the Clean Air Act is one example where the agency writes regulations for categories of sources saying, here's best available technology for this source. When you build it, you got to put it on, period.
well,
That's a good example. There are also hazardous air pollutant standards that are directly applicable to the source as opposed to the ambient air. If we think about it, the analogy in the water, in the context of wastewater discharges, is that when we look at the water quality of the bay, that's the ambient water quality. And there are applicable water quality standards, the criteria that this water should meet the following criteria. For example, so many parts per million dissolved oxygen, temperature not greater than this or that. And there are actually criteria, very detailed criteria, for things like mercury or lead or these heavy metals and other pollutants like nutrients we talked about. So those apply to the water, but then it's up to the states or someone to figure out how you translate those ambient standards back to permissible additions from wastewater treatment plants, for example, or from power plants or other industry.
and the nuclear plant, I looked up how many generators we have in the state, and I went to the site for Calvert Cliffs, and the amount of education that these people have to take on a regular basis, plus they have a paramilitary. So I don't know how the EPA regulates nuclear waste, but it's huge in terms of protection.
We'd have to order in dinner to get into that subject. It's one of the more complicated and tangled messes in all of environmental law, quite frankly, because you're talking about overlaps between the Nuclear Regulatory Commission and the Environmental Protection Agency and
the Department of Energy.
And the Department of Energy, and
Right.
there's some that you can't get there from here situations that you get into when you get into that little tangled quagmire. So that I would advise we not go there.
But just like a what if? What if a power plant was going to be built, not in Maryland, in another state, in a contiguous state, and then it doesn't necessarily have to be contiguous, because with the airflow acting the way it's acting lately, I mean, we can be impacted, and states can be a couple away from us.
Yeah.
So then you have this airflow that's coming towards us, water flow and airflow towards us, and how we're going to be impacted. And so then we have to say, well, is the state going to be able to protect us, or is the federal government going to be able to protect us? Or are we looking at both entities in protecting our welfare?
Well, under current law, you're looking at both entities. In the example you give, a new coal-fired power plant, I'm assuming you meant coal-fired, in, say, Pennsylvania, would require air permits, water permits, waste permits, lots of permits. And through that permitting process, local and more remote issues would be addressed. You'd have to demonstrate. Let's break this down and talk about pieces of it, and I think they'll illuminate the problem. Just take the air piece. You'd have to demonstrate to the permit writer that you're proposing to install the best available technology. And there's a whole set of tests for that. And then you have to demonstrate that with that technology, the emissions impacts of your source, both locally and regionally, are going to be acceptable, meaning that they're not going to offend the National Air Quality Standards just for openers. And if you end up getting a no answer to that question, meaning, oh, you're still going to impact them, then you got to go back to your technology and ask, and maybe go, instead of with a Chevrolet, go with a Cadillac technology, so that you can not cause adverse ambient impacts. And then, and this is an important component, you've got to basically lay all that out for the public to look at with a proposed permit, and there's opportunities for input, and which is one reason why the current system really does make sense, because it has elements that a simpler system that some have advocated, like why don't we just leave it to the courts, doesn't have a public participation component. And importantly, the public comments that are adduced have to be responded to reasonably, because the courts are sitting there refereeing the adequacy of the responses.
And in that public process, in the public participation process, the state, and the example we took, a plant in Pennsylvania, for instance, Maryland will receive, the environmental agencies in Maryland will receive notice about the permit application by this plant in Pennsylvania, and Maryland will have an opportunity to have its voice heard. And then EPA, it has oversight role to look at that permit and to consider whether Pennsylvania has adequately taken Maryland's concerns into account. Mm-hmm. And if the answer is no, then EPA can go back to Pennsylvania and say, hey, look at this again. You need to look at this again. And ultimately, EPA can effectively veto that permit or hold it up. Well, nobody wants their permits delayed.
And there's another wrinkle in this too, which is interesting. Your example might involve locating a source in a non-attainment area, meaning an area that already has more pollution of a particular type than it can stand. So what do? Do you say no growth whatsoever? Well, environmental laws addressed that problem and said, no, you can still build there. But what you got to do is you don't put on the Cadillac technology, you put on the Mercedes-Benz technology. Mm-hmm. The Clean Air Act acronym, and EPA law is full of acronyms. It's LAIR, lowest achievable emission rate, which means the Mercedes-Benz technology. And then, in addition, you've got to take a look at the emissions that even with that Mercedes-Benz technology you're going to cause, and you got to get offsets for it. So you got to basically go off and show that you're buying reductions somewhere else in that same airshed that make room for the additional emissions that you want to impose. Very tough tests.
Well, I think it's exciting that the younger generation, not to say we're old, But the younger generation is more educated about the environment than, we are. We are educated as much as we can, but they, I guess, are even hungrier. And so that public process of the comments that are necessary will help. So we're going to take a break now, and
Okay.
we'll be right back.
We are MCTV, Midshore Community Television. We want your help in making our station more robust so that we can better serve the residents of Talbot County. So, how can you help? If you are already making video content, submit that content for broadcast to the station. It's free! Are you involved in events, shows, or lectures that would be of interest to the community? We can work with you to figure out the best way to capture those events for airing on MCTV, be it training, equipment rental, or hiring our production staff to film at a reasonable rate. Do you want to produce your own show? Let us help you get started. Come be a part of this valuable community resource. Email the station at nick@avalonfoundation.org or visit us in the basement of the historic Avalon Theater at 40 East Dover Street in downtown Easton.
Hi, we're back, and we're going to talk about the Susquehanna River and the Potomac River, the rivers that flow into the Chesapeake Bay. Chesapeake Bay is the largest estuary in the country, and as such, we are affected by what happens upstream. Rivers, water flows, and air. So let's talk about how something like farming impacts in Pennsylvania. Farming in Pennsylvania impacts our Chesapeake Bay.
Well, the Susquehanna River watershed is a textbook example of why an approach to protecting the environment that focuses exclusively on state level controls isn't going to work, because growers in Pennsylvania are contributing significantly to nutrient pollution in the Chesapeake Bay. But if I'm a grower in Pennsylvania, the Chesapeake Bay is about as remote from my concerns as something that's going on the moon. It's just not near. It's 200 miles away, and it's somebody else's problem.
Right.
So you need a structure that forces regulators to take a regional or even a national view of a problem, not just an individual state view, which is the approach and such approaches are built into our current environmental laws. But it's worth noting that there are some problems that even regional or even national approaches don't work for, and global warming is the paradigm example for that. What happens everywhere in the world affects greenhouse gas levels, and therefore you're going to address that problem. You've got to have a worldwide solution, not a single country solution.
Bill, getting back to rivers and the Potomac.
The Potomac River is an example that Maryland and the District of Columbia own the Potomac, and yet it separates from Virginia. But Maryland's waters run right up to the Virginia shore, so anything that happens in Virginia and runs off of that shore, or that Virginia allows to occur to affect the Potomac River, directly affects waters of Maryland. It's another example of how we need something above the individual states in order to be sure that one doesn't unduly adversely affect another.
I did some research on oystering, and I have to just put this as a sidebar that there have been wars between Virginia and Maryland for over a century about who owns and where the lines are for the Potomac and for the Chesapeake Bay. And when Kennedy was in office, they still had boats out. I mean, they were going to war over who owned the Potomac River. So anyhow, that's a sidebar. It has nothing to do with the environment per se, but I'm just saying that's fairly recent.
Well, it does make the point that states don't always get along, and you need in a federal system you need somebody around that's going to basically knock some heads together and get people
Right.
working on the same sheet of music.
Right.
It also makes the point that each state is going to jealously guard the economic interest of its own residents. I mean,
Right.
it's the Virginia waterman versus the Maryland waterman,
Right.
and Virginia is going to be promoting the interests of its own watermen, just as Maryland will do. And
As well we should.
And indeed that's what politics gets down to. I mean, nobody in Virginia votes for representative or delegate in Maryland. They are elected and serve at the pleasure of the voters of Maryland, right?
Right.
So they're not beholden to somebody. And if you take Pennsylvania, the Pennsylvania legislators are not beholden to Maryland voters or Virginia voters that may be adversely affected by pollution coming down the Susquehanna River.
Which is why you need federal supervision, is what it comes
Right.
down to, yeah.
There's a great incentive to take care of your own when you get into the state politics and local politics, and thus something above the states, some umpire has to sort of keep things fair and equitable among the states.
And so these traffic ways, these waterways, these rivers are what joins us and yet pulls us apart.
They could. They absolutely could.
Yeah.
Yes.
Well, and of course, the same is true of air. We live in an ocean of air, and air doesn't respect state boundaries or even international boundaries, as a recent experience with tropical storms points out.
Yes.
Yeah.
Well, let's segue here into how a law, Congress, well, I want to go to Aaron Brockovich, because everybody knows Aaron Brockovich as a buzzword, at least, the name. And what happened out in California with toxic waste getting into people's water systems. Were there laws in place, or because of the Aaron Brockovich case, did laws then were enacted to safeguard people's water systems in California?
Well, Bill, you're more of a water guy than I am. Maybe you should take the lead on that.
Laws were absolutely in place, but you have to go back a little bit. For years, we had, through the 1940s, 1950s, 1960s, post-World War II, and during World War II, there was a lot of unregulated disposal of industrial wastes that occurred throughout the country. You sort of fast forward to the mid-1970s or so, and we had the notorious case of Love Canal in New York. Love Canal turned out to be a school had been built on top of a toxic waste dump, effectively. And the discovery of that then led to the passage in 1980 of a federal statute called, the long name of it is the Comprehensive Environmental Response Compensation and Liability Act, fondly known as Superfund.
Or CERCLA.
An acronym.
For short CERCLA or Superfund statute. There was a direct response to the discovery of these waste sites, illegal waste sites, or legal ones, in fact. But they were adversely affecting. Yes, they were legal at the time that they were done. Up until 1974. 1974 was the passage of the Resource Conservation and Recovery Act, which was the first big, grand, hazardous waste statute that was passed by Congress. As part of our
Under the Nixon administration.
In 74, I think actually by that time, it may have been Ford.
Well, RCRA didn't have any teeth in it until about 1980.
Well, that's when all of the regulations came into
because
place.
the initial formulation of RCRA allowed the EPA to issue guidance on waste disposal that were binding only on proprietary activities of the federal government. And just as an example, my first EPA job, I was in a division called the Pesticides, Toxic Substances, and Solid Waste Management Division at OGC.
Right.
And the waste component of our work was 1/3 of an FTE, meaning a third of a person in the entire division. And in 1980, when RCRA and Superfund came along, the two programs essentially devoured the agency. They became the major new focus. And they're the only example of programs that have grown up out of the ground, basically, during the existence of EPA. All the other programs had antecedents, which we'll probably get into later, in other agencies that became part of EPA by a stroke of President Nixon's executive branch reorganization pen.
Yeah, but for example, the first sort of we'll have to come back. We'll come back in a moment to
Okay.
the Superfund and how that affected Aaron. But the first really comprehensive federal statute about regulating water quality was in 1948. But even before that, in 1899, Congress passed what the Rivers and Harbors Act of 1899 included a Section 13 that was fondly known as the Refuse Act. And under Section 13 of the Rivers and Harbors Act of 1899, one was prohibited from putting refuse into navigable waters. And there was for a long time, you had to get a permit in order to be
So
allowed
what is
to put
navigable
refuse
waters?
into navigable waters.
That's a
Well,
debate that's still going on.
that's a great question. But it's water that is susceptible of use or has ever been used for commercial purposes. For example, if a trapper back in the day when this continent was being settled could paddle a canoe full of beaver pelts down the water, that was probably navigable. And that was historically a navigable water. Okay?
And under the Obama administration, complicated jurisdictional regulation on navigability. It included underground groundwater resources that had, quote, connectivity, quote unquote, to things that some trapper might have paddled a canoe on.
That's not just no. It's not true that that's only under the Obama administration.
Okay.
There is a 1971 case out of the First Circuit called White Fuel Oil Corporation, in which the First Circuit, United States Court of Appeals for the First Circuit, held that the underground transmission of oil or oily material from
Was a
oil
discharge?
storage depot was a discharge prohibited under the 1899 Refuse Act.
Well, fair enough, but I think the Obama administration interpretive rule is an attempt to restate and
maybe
rationalize
expand.
and maybe expand,
Expand.
what the jurisdictional reach of the Clean Water Act is under the concept of navigability. And I said it's a debate still going on because the current administration is reconsidering that rule.
During the deliberations on the 1972 Federal Water Pollution Control Act amendments, and the act that they were amending, by the way, that was the one that was enacted in 1948. So 48, and then it gets amended in 66, 67, and then finally the major amendment in 1972 as part of what is still our organic federal environmental law exists today. But during that debate, it was pretty clear in the Senate. The sponsors of the legislation stood up and said, when we say waters of the United States, including not just navigable waters, but we mean waters of the United States, we want it to be given the broadest possible constitutional interpretation. That's what they said.
That has the ring of a
beginning.
Leon Billings authored statement.
Well, so
It may have been Leon.
Leon was a staffer for Senator Muskie, who died recently, and he was one of the great architects of our current environmental laws.
so we can blame him.
Or blame him or give him credit.
Or give him credit, right, whatever the case may be.
And in context, of course, Senator Muskie at the time was also vying to become and became the Democratic nominee for president, running against Richard Nixon in 1972. So there was a big political tussle between the Republicans and the Democrats over
Well,
that
when I so
statute.
rudely interrupted you just a few moments ago about it. In 1974, Nixon. I don't have my calendar in front of me to see when he was the president, but in fact, the EPA came about when Nixon came into office. Correct?
Well, in April of 1970,
1970,
I think it was, he actually created EPA by reorganization plan number 3 in 1970. And David and I were talking earlier, and we think that the statute under which he was allowed the executive reorganization authority to create EPA, it probably could not be done again today in quite the same way.
And in part because it created a real mess. I remember one of the early administrators had a chart on his wall that showed the various congressional committees that he was beholding to. And what happened when Nixon reorganized the federal government, Congress didn't reorganize in parallel, so that all sorts of congressional jurisdictional responsibilities that made sense under the earlier structure didn't make sense when you had EPA basically running things. So one program at EPA would end up having oversight by several congressional committees who often didn't get along very well. So
Right.
that may be one of the reasons why Congress thought better of giving the president authority to reshuffle the deck as Nixon did.
Right.
But just to fill that out, that story, the original EPA programs were all came from other agencies. The water program came from the Department of Interior. The air program came from what was then called the Health, Education, and Welfare. The pesticide program came from two agencies. It came from FDA and from the Department of Agriculture. And all of these people were basically all of a sudden had new bosses. And for many years, 3 or 4 years, EPA didn't have even a single building in which everybody resided. People were scattered all over town, which meant it was really chaotic to try and get together for a working group meeting, for example. But that all resolved itself during the latter part of the Nixon administration.
It was also somewhat chaotic for those of us trying to practice law in the private sector at that time because EPA was so scattered around D.C. I mean, you just about had to have a pack of hounds to find out where EPA was,
Well,
where the office was that you
We
needed
want
to
to
meet
we want to
with.
feel sorry for you, but we want to get back to Aaron Brockovich.
Well, which takes us back to the Superfund statute. Superfund was about identifying, holding accountable those who caused the pollution, the contamination, and requiring cleanup and prioritizing all of this list. Interestingly, one of the things that happened after EPA was formed is that Congress repeatedly, essentially ratified the formation of EPA by creating a statute and assigning specific responsibilities to EPA. Lots of things say the administrator of EPA. But there are also instances in which, for example, in Superfund, when the Congress charged the administration, charged the government with coming up with a priority plan for how you go about attacking these, ranking the sites and figuring out which are the worst and attacking them in some sort of logical order. It charged the president with coming up with this, and the president then in turn delegated those functions and
That's very
roles to
interesting.
EPA. So lots of examples of in the environmental
Interestingly,
statutes where the president is the one who's responsible.
CERCLA has often been criticized as being overly complex and in some cases not parsing very well. It was written very quickly, but
What, David, say
not
that again?
parsing very
No,
well.
I heard that part. What was the?
Overly complicated and sections that were in conflict.
Superfund statute,
Superfund
CERCLA.
statute. But
Called.
well, it's called CERCLA as the
CERCLA.
acronym, or commonly referred to as Superfund. But an old client of mine who was liked to boil things down said CERCLA really isn't all that complicated. It's like your mother telling you to clean up your mess, and it's essentially what it boils down to.
Right, right.
Yeah.
Okay, well, we're gonna. I'm
And this,
sorry,
and this other statute that came into place, the Resource Conservation and Recovery Act, was to prevent future problems from occurring by strictly regulating from the cradle, from the birth to the grave, all hazardous waste generation and disposal, management, and storage in the U.S. And those functions, initially fulfilled by EPA, were then parceled out and assigned to the states under delegation with EPA. So the EPA delegated to the states the authority to go forward, but again, subject to EPA oversight. So the disposal that resulted in the well problems in the Aaron Brockovich case may have been legal at the time it occurred, but the effects on the groundwater under something in California called the Porter-Cologne Water Quality Act would have been illegal. And under the Porter-Cologne Act, which was enacted, I think, in fact, before our federal statute in California, the California law would have made it, placing anything on the ground subject to that statute
I think
to
the
protect both
pollutant,
surface and groundwater.
pollutant in question in Aaron Brockovich was a
Chromium.
chromium.
Chrome 6, yeah.
Chrome 6.
Hexavalent chromium.
Hexavalent chromium, yeah.
Right.
Yeah.
But there, the other example is popularized in the movie A Civil Action. It was about trichloroethylene contamination of drinking water wells in Massachusetts. It's another good example in which the original disposal may have been legal, but the unfortunate effect on people's well water and thus on their health was not legal.
Well, gentlemen, we are going to take a break, and we will be back in a few minutes.
different than any place I've ever been. It's easy to just be in the room with everybody else and enjoying the show together.
I'm very impressed. Just the variety, the quality, the intimacy.
Welcome back. We're going to do our closing arguments here, gentlemen, that you're both lawyers. I'm sure that you can do them well. So some have talked about doing away with funding for the EPA, which in effect would do away with the EPA. Bill, can you address that, please?
Well, I think it's not a good idea. I think we desperately need to keep EPA. We all depend upon EPA for our health and welfare in ways that we don't even think about, don't even occur to us. But to go back to our interstate transport of pollution, either in the water or the air, is a prime example of why it's not a good idea to leave it to the states. We tried that before the 1970s, and it really didn't work very well. Because the incentive of the states is to attract economic development and economic growth, you could end up precipitating essentially a race to the bottom as each state tries to be nicer to industry than the next state in order to attract more industry to come to that state. You also have, EPA has developed an immense technical capability, scientific capability. It doesn't make sense to replicate that from state to state, to try to have the states develop that same kind. Some of them, like California, are wealthy enough that perhaps they could afford it. New York, perhaps they could afford it. But states like Delaware or Rhode Island or Iowa or other states, to have to do that, and it doesn't make it's not economically efficient, or it doesn't really make a lot of sense to replicate that kind of expertise in 50 different states. And then there's the problem of confronting industries that we represented, that I represented, of having to try to contend with multiple 50 different states or 55 different jurisdictions, standards. You've got, because of Puerto Rico and other U.S. territories, you're really talking about 55 or more jurisdictions to have to contend with. And David, you can expound on that from your experience.
Well, there's another problem, and that some of the pollution sources that you're regulating are actually products that people manufacture and sell, and hope to sell to a national market. So you need one set of standards as to what levels of emission control you need to achieve, because industry simply can't deal with 50 different standards, much less even 20. Cars are an example that the Clean Air Act itself had to confront, and when the Clean Air Act amendments of 1970 were enacted, emission control for vehicles was what part of that package, and the auto industry wanted a single national standard, and California, which is essentially like a separate country, came in and said, we got separate problems, we need our own authority to create our own, and the Congress allowed California to create separate standards for cars and trucks, provided that EPA reviewed them and waived the requirement for national uniformity, which it routinely has done. And interestingly, as the pollution problems from tailpipe emissions have increased over the years, many other states have adopted the California standards, particularly up and down the eastern seaboard, which has created some problems which we don't have time to get into here. But essentially, auto industry is still only required to build two types of cars, California cars and, for want of a better term, and rest of the United States cars. I represented for years the trade association that represented the hearth industry, wood stoves, furnaces, things like that, things that create smoke. And we actually went in and virtually begged EPA to regulate us at one point 20 years ago, because the EPA hadn't regulated us, and the states were concerned about it, and they were starting to go in their own way. We had standards in Colorado, we had standards in Oregon, Vermont was sniffing around wanting to do it, and the manufacturers were apoplectic. They said, we can't build 5 or 6 different types of these
Yeah.
appliances. We're a small industry,
Right.
and EPA agreed that it was a major pollution source, and we ended up promulgating standards. And there's no preemption in federal environmental law. States have authority.
Well, the Tax Exceptions Control Act has preemption
Well,
for
that's
things like
a,
PCBs and so
okay.
forth.
Okay, that's true. But for the most case, there isn't. The states have authority to regulate more stringently than the federal floors. Very few. That is exercised very infrequently because most of the states don't have the resources to second guess EPA decisions, which by and large are pretty solid anyway. And that's essentially the history for in the arena I worked in. The states didn't bother to promulgate additional regulations for hearth appliances, and in fact, some of the states that had them did away with them because it was inefficient for them to continue to administer these programs with the federal government occupying the field effectively.
California is probably the lead example of a state that has taken the step of being more stringent than the federal floor, than the federal minimum standard. I mean, there are several areas in which California does that. But much more common is a state, one can find many state statutes that say, dear state agency, set these standards, but whatever you do, don't make them more stringent than the federal EPA standards. We want to just be
Exactly.
as stringent, but not more stringent.
Right.
Which would create interesting problems if EPA disappeared. What would
What would that level be?
that level be?
What would
Yeah.
it become? But imagine, David gave you the example, that example of his wood stoves, for instance. But you can also think about lawnmowers or chainsaws or
Yeah.
all of these other pieces of equipment that for which states could establish separate standards, and it would be a nightmare.
It would be a nightmare.
Right.
We haven't talked about the court system and how there is the thought that we'll let the courts let them decide in the courts what's going to happen. But we'll do that for another time. What I'd like to say to both you all is, or ask you on a local level, what efforts you have done on your volunteer time to help the environment.
Well, I am happy to serve on the board of the Midshore Riverkeeper Conservancy, and in what we have, MRC together with an organization in which David is heavily involved called the Chesapeake Legal Alliance, have recently produced a manual, a citizen's manual, basically for participation in the permit process, how to go about getting your comments in the best way possible on proposed wastewater discharge permits that may affect the water quality of the tributaries of the Chesapeake Bay or the bay itself. So this manual is available. You can go find it on the website for the Chesapeake Legal Alliance or on the website for the Midshore Riverkeeper Conservancy.
And let me talk briefly about the Chesapeake Legal Alliance. I'm on the board of that organization. One of the things I elected to do to sort of keep my hand in after I retired in February. CLA does educational outreach activities like the one that Bill just described, and in addition, and probably its primary function, it serves as a clearinghouse for activist groups and citizens groups that are looking for representation, and major law firms that are willing to donate their time pro bono. And we've made a number of important marriages between groups and law firms, and they who have in turn brought cases that have had a major impact on Bay issues, and will continue to do so in the future.
Well, we are excited to have had this opportunity to be with you all and to
Thank
talk
you.
about the environment here on the eastern shore of Maryland, the Chesapeake Bay, and thank you for being here.
It's been a lot of fun. Thank you.